keynote address followed by paper presentation. Our first paper presenter of today's event is Dr. Lisa Thomas, Assistant Delhi University, American Literatures and Law and Literature. Now I
Good evening, one and all. I take this opportunity to thank Professor Shreya Bhattacharjee, Professor Srinivasan, the organizers of the research club, for giving me this opportunity to present my paper. I'll try to stick to my time, that is 20 minutes. Let me just share the PowerPoint. Okay. I hope you all can see the slide. Well, first of all, I'll present the argument. When we look at the legal narratives that are from India, legal narratives that are around transgender subjects, we often find that the human body is reduced to its genitalia when it comes to understanding the gender of a person. Often in this course of reading a person's gender by looking at one's body and one's genitalia, it causes a kind of a violation to the person whose body is being read. So that is one problem that I've identified in the Indian legal judgments, Indian judgments on transgender persons. Even the judgment that recognizes transgender persons as persons' rights, even that particular judgment has certain code readings of human legal person and their bodies and their gender, body gender relationships. So when I understood this problem, when I look at the poetry that is being written by transgender persons, what I see is that there is a response to this kind of a reading of one's body and one's gender. So though I kept the title very broad, in this presentation, I'll be focusing only one poem that is written by a trans-identified poet, Dayanti, and the poem's name is Submission. And in order to bring up a proposition, the proposition to this problem is that when we look at legal personhood, the idea of personhood, in the classical view, what we see is that it is often understood as one that is limited to oneself. I'll discuss this in detail. I'm just presenting my argument. So, the argument is that it is important when we consider one's personhood, it is important to not just look at the self, it is important to look at one's body also. And while we understand a legal person as a person with body, it is also important to understand that a person can have some property relations with one's own body. So we often see this cliche statements that it's my body, my right, but one cannot have this full rights on one's own body. We don't really own our body that completely as per law. However, the argument is that it is important to have some property relations with our body. So we can say that I have some rights over my body. It's my personal property. And therefore, I have a right to name my body as a particular gender or ascribe a gender to my own body. So this is the basic, very, the very crucial proposition that I want to make. While we understand personhood as one that looks at one's self and body, it is also important to draw a relationship between personhood and property relations, and it is also important to consider one having bodily rights that extend to a position where one can claim a gender and not allow another person to, ascribe a gender to our own body. Okay, so I assume that you know I'm unable to move to the next slide. They are not considered as legal persons. Then now, when it comes to the views on personhood, what we see is that, uh, as I said earlier, be it for Immanuel Kant or John Locke, even Hegel also, for Hegel it was, personhood was an aspect of, one being able to exercise one's will over thing with the use of the external property. For Locke, again, it was a legal person was a person who could use one's consciousness. So here, if I read from the slide, it says for Immanuel Kant, the person is a free and rational agent whose existence is an end in itself. Kantian view of person focuses on universal abstract rationality. In this view, personhood one from another. Intelligent being that has reason and reflection and consider itself as itself the same thinking thing in different times and places. That is, person is equated with self, and this leads Locke to the claim that every man has a property in his own person. The labor of his body and work of his hands, we may say, are properly his. So, what you may want to take note of the classical views on personhood is that the self was given more importance than one's body. So this, we can say, was also influenced by the values of the church, wherein the church actually focused on the soul and the individual rather than the body. The body was just seen as an encasement for the soul. So yeah, that is there. And um, from the classical view, we see a criticism from Margaret Radin. So she theorizes this relationship between property and personhood, and she criticizes the earlier philosophers for not actually looking at the possibility of a legal person having a body and mind, a self and a physical body as well, and also the possibility of a legal person establishing some rights over one's own body. So Radin suggests that to achieve proper self development and to be a person, an individual needs some control over resources in the external environment. So there is this idea of human flourishing, which is which can be read from the philosophical engagements of Aristotle onwards. Many theorists have actually engaged with this idea of human flourishing. That is, one can develop into a meaningful legal person, or have a meaningful life by developing into a proper legal person by establishing some relations with the external environment. So one doesn't just look at one's own self, but one would also look at one's relationship with the environment, with other people also, and with the society at large as well. So, what Radin says is that in order to have a proper self development, one needs to have some property relations with the environment around them. And when we consider this right to property, that one has to also consider one's personal property. So there is this idea of fungible property, which can be considered as a commodity, which can be bought and sold. And there is also this idea of a personal property, which needn't be an object or a commodity or a product, but it can be certain personal attributes also. One's body also can be considered as a personal property. So the idea of personal property that is bound up with one's personal identity becomes important for personal autonomy and liberty. So, how do we decide which property is to be considered essential for one's personhood? To decide which property is to be considered important, we may have to consider what property is crucial to the person's identity, or one that amounts to one's defining characteristics. So she says, if it makes sense to say that one owns one's body, then on the embodiment theory of personhood, the body is quintessentially personal property because it is literally constitutive of one's personhood. Therefore, if human body is constitutive of one's personhood, the right to choose one's gender and the freedom from bodily intrusion are inalienable rights that allow one to develop into a rights and duties bearing legal person. So that's the basic argument of this presentation. Now, as I said earlier at the beginning, when we look at the legal narratives from India, there is a flawed reading of the body of a transgender person. This is what I meant. So, this is the very popular National Legal NALSA, or National Legal Service Authorities versus Union of India judgment. And if you look at the very opening line of this judgment, it says seldom our society undergo nor appreciates the innate feelings of the members of the transgender community, especially of those whose mind disorder, emphasis that is given on the biological sex. So not the way actually the understanding sex as the true sex in order to think of claiming a transgender identity as a condition where one's mind and body disowns their biological sex. And within the judgment itself, there is a section that talks about gender identity and sexual orientation. So in that part also we see that this one's need to transform from one gender to another gender as being seen as a reason, not reason, is seen as a requirement that comes out of some kind of a problem. So it says genital anatomy problems. So I'll read that part. It says gender identity is one of the most fundamental aspects of life, which refers to a person's intrinsic sense of being. So that is being identified as a one's person's intrinsic sense of being. So it can also mean as one's sense of one's personhood. Being male, female, or transgender or transsexual person, a person's sex is usually assigned at birth, but a relatively small group of persons may be born with bodies which incorporate both or certain aspects of both male and female physiology. At times, genital anatomy problems may arise in certain persons. Their innate perception of themselves is not in conformity with sex assigned to them at birth and may include pre and post operative transsexual persons, and also persons who do not choose to undergo or do not have access to operation, and also include persons who cannot undergo successful operation. So it is basically giving a description for uh, uh, the transgender gender, and giving reasons as to why this kind of a situation arises wherein one person would want to transform from one gender to another. Now, coming to the poem, it is this is the poem that I mentioned in the beginning. The poet can be named, can be called Dayabi or Dayanti. And the poem is Submission, which is from the anthology The World That Belongs to Us, which was published in 2020. Um, so it says,
presented itself in the form of today's discussion. Law is um, importance. One wrong word, one missing word could lead to a pandemonium. So and if we have seen throughout history how law has evolved, a piece of law is written, then people try to follow it. People who don't want to follow it find loopholes in the law, then they exploit the loopholes. They commit frauds, they commit crimes, they commit um, unspeakable things, but they find loopholes. They try to find a word which could mean several things, or a missing word could be there. You said this but not this. So they try to find loopholes like that, and they go away from the grasp of law. Even if the government tries to punish them in the courts, they have their say because they have found that loophole. Then what happens is law again evolves. Again, the matters are sent to the parliament. The parliament makes changes to the laws, corrects the words which are there, and then it comes takes a new form. The law takes a new form. So law has been for a long time, and the evolution is through the changes in the words which are there. And so law, how it is drafted is it has to be drafted with foresight. It has to be drafted in a very, very nuanced manner, and one has to be a person who appreciates the English language, because our country especially, we follow English as the primary language in which law is written and practiced. So a person necessarily has to have a very good appreciation of law if one has to draft the law, if one has to understand the law, and one has to apply the law. And the just like J.R.R. Tolkien uh, had evolved his own language while writing the Lord of the Rings, and it had its own rules and constructs. And just like in Harry Potter, where J.K. Rowling had the spells and the world, she built a world of her own. Law is also, the legal world also has its own rules and constraints, how things should be understood, how the words have to be understood, how a sentence has to be understood, how a particular phrase has to be understood. And um, law is not mathematically precise, because English language is not mathematically precise, and each word could have different meanings. Each word could mean different things in different contexts. Even in within the same context, within the same piece of law, if the same word is used in different context, it could give rise to ambiguous meanings. And because of this, it leads to loopholes also. So law has to be drafted with a lot of carefulness, and a nuanced understanding of the society, the needs of the human beings, and how, and it also needs empathy, what this would mean to a person who sits on the road, who leads their lives in a normal way, what this could mean to a person who wants to abuse law. How would he be able to find the loopholes? And that a sort of putting yourself in someone else's shoes should also be there. And it may not be law, the written text of law, if you read it, it is not emotion evoking, it doesn't evoke any emotional response in a person. As such, it is not very descriptive, it is not it doesn't use adjectives, rarely it does so in a descriptive manner. And so it may not look like artistic literature, but nevertheless, since it has the force of law and since it is enforceable, um, how law is being drafted plays very very great importance in the society. And even in the little things it could come out, like the difference between the words shall and may. Shall means it is used in an obligatory sense. You shall do this means that you have to do this, otherwise there's a punishment. You may do this means that you have the discretion whether to do it or not. So if you don't do it, there is no punishment. But there are places where may has to be understood as shall also, where the legislators meant to say that this is something which is obligatory, but they use the word may. To err is human, so there are places where especially because laws are very often they are hastily drafted, because there will be international pressure to bring out a new law, there will be internal pressures from various organizations to bring out a new law. So in all these things, the draftsmen, they do commit unintended errors, so that could also be there. How should we understand, how should be understood when understand the words when they are used wrongly? That also is being dealt with by the various rules and constructs which are there in the legal system. And even smaller things like and or, these play very great importance. And use of these words may look inconsequential, but these are some of the words using which many frauds have been committed, many tax avoidance has been committed, many crimes have been committed by twisting the meaning of the words which are being used. And the legal system is also full of something called legal fiction. Legal fiction is like a deeming fiction. Something is not something, but it will be deemed to be something. Most of the pieces of law, most of the legislations have such something called a legal fiction. You are not this, but you are deemed to be this. For example, as Lisa ma'am was talking about personhood, I was reminded of how the word person is being used, not in the sense of the sense in which Dr. Lisa ma'am presented her paper, but in the sense of, like ma'am said, uh, the collection of rights and duties. Who are persons? Generally, we understand human beings as persons. Generally, in English literature or in normal language, when we normal conversations, person refers to a human being. But in law, most of the pieces of law, person also refers to an artificial person. Whenever we say person, it could also mean a company, it could mean a firm, it could mean an artificial corporation like LIC, it could mean an artificial juridical person like a deity or some other entities. So these are legal fictions. That is, something may not mean something in the normal sense of the word, but law is also full of these deeming fictions. And in most of the places it includes artificial persons also. And law is full of definitions. These are not universal definitions. For example, the income tax act, because every one of us have to pay income tax, and tax planning will be involved in all our lives at one point of time or the other. If you take the income tax act, it's a very very complicated complicatedly drafted piece of law. Because for example, the same word relative could have different meanings in different provisions, different sections. So whatever definitions and meanings that we find in the world of law, are largely localized, they are not universal meanings. And the law is also full of references, or it uses a lot of archaic English. And like for example, when I write, because I'm largely dealing with law in my day-to-day life, so my normal writing itself would normally contain these words, because these are part of the law which we deal with every day. At least in Indian law it's still like that, but in other countries, when I look at their pieces of law, I see that more simpler English is being used. But in our country, we still use the archaic or the middle English type of words. For example, something that we don't normally use in our day-to-day language, like notwithstanding anything contained in some other act, therein, therefore, or I have written here, whereas something happened, and now therefore we are passing this law. So these sort of constructions, these sort of, not necessarily words, but these sort of constructions and phrases which we don't normally use in the day-to-day conversational English, they are still part of English Indian law. Indian law, I mean, because our law is based on English law, and English law is based on has been evolving for a long time. And there are a lot of Latin terms also that form part of the written word of law, as well as in the legal system we use a lot of Latin law, and English law is based on Roman law. So according to the Western type of thinking, Rome was the birthplace of law. That is how the present structure of law, it is based on the Roman laws. So, for example, words like prima facie, mutatis mutandis, in in a normal legal conversations, mutatis mutandis means with necessary changes. Prima facie, from the looks of it, principles like nociter associes, know something by its association. Tell me who are your friends, I'll tell about you, like that. Ejusdem generis, a general word following a series of specific words will be given narrow interpretation. So these sort of things, a lot of Latin phrases are part of law. This usually reminds me of the spells like expecto patronum, pia totum locomotor, of Harry Potter. But these are very, very interesting for a student of law to see these terms and use it, because if one is a fan of Harry Potter, they'll be definitely be enjoying learning all these phrases. And now coming to law in, so the point I was trying to make was, law has to be drafted very, very carefully, because thousands of crores of money um, are being evaded in the form of tax evasion. I'm talking about tax avoidance strategies, um, mainly because of the loopholes in the written form of law, the litera legis is what we call as the written law. So the litera legis is being given a lot of importance by the courts, and the courts are very, very, see, you should understand that there is a difference between law and justice. It is for the purpose of justice that law exists, but still one has to be conscious that um, the courts can deliver only that justice which forms part of the written law. So that is why the written law and how law is written has to be very, very careful, and that's why I consider it as a genre of literature in itself. And now coming to law in artistic literature, this is something which I find very, very inspiring and interesting, especially as a person who practices a part of law in the daily life. Um, I have enjoyed some novels of Sydney Sheldon, and Shakespeare. Most of us have grown up with Shakespeare. At least in the schools we have learned, and John Grisham's novels are a favorite for many. And these novels add the humane part to the provisions of law. Law, if you read the text, it is even something which is very, very significant will look very mundane. So people would sort of miss out the importance of such a thing. There is an act called the Limitation Act 1973. People would tend to forget that there is a piece of law because it is not often forming part of the discussions, and people would tend to forget. Even those who are practicing law could sometimes forget that such a thing exists. But what happened was, I sort of ran into the book Sidney Sheldon's Rage of Angels, and it contained a very poignant discussion on several legal concepts in a matter of 2 to 3 pages. The protagonist of Sidney Sheldon's Rage of Angels is a lawyer herself, and she tries to bring justice to a person who's a quadriplegic amputee because she was hit by a truck. We see these cases often in the real life, hit and run cases. So in this particular thing, she tries to bring justice. The person who suffered the accident, who became the quadriplegic amputee, she tried to sue the corporation which made the trucks the deficient. Had some technical deficiency in the braking system, so that's why the truck malfunctioned and hit her. So she tried to sue them. She lost. She made an appeal. She lost. She goes to another lawyer who is the protagonist, and the protagonist tries to rekindle the case again. So when she tries to rekindle the case, a case which is already closed in the courts will not be reopened. So there is a principle for this called res judicata. So this is very beautifully explained in this particular paragraph. What's res judicata? Ken Bailey asked. Jennifer explained. Jennifer is the protagonist. It means for civil cases what double jeopardy means for criminal cases. There must be an end to litigation. So what has already been litigated and closed by the courts will not normally be opened. So once a final judgment has been made on the merits of a case, it can only be opened against very special circumstances. And Jennifer, the protagonist, is aware of this, and she says, "Yes, I know this. I will go after them on discovery." So discovery is again a very, very technical legal term. So the principle of discovery is that all facts which a person knows in a particular litigation has to be made known to the other person also, so that there is complete transparency between the two parties. What are the facts which are there with each other? So that is called discovery. So if somebody hides something in the process of discovery, then she says that it can be reopened, the case can be reopened, and that is what she's going after, because it seems that there was a problem with the truck's braking system, and that was hidden during the previous litigation. And so based on that, she is going to complain to the courts again and reopen the case. But then so she goes to the other, that truck making corporation's lawyer, and she says, okay, so I'm going to reopen the case. So she just goes there to the lawyer of to the advocate of that company, saying that I'm going to reopen your case. If you go to the courts, it will take a lot of time, and I'll also claim $5 million. But if we try to settle it outside of the courts, I can just agree for $2 million. And that other person hesitates in the beginning, but then he agrees. But he agrees very, very easily. Okay, I suppose we may be able to arrange for something like that, he says, next week. So she waits. So she waits till the next week, till that day comes. But that particular day, he says that he is not available. And she has been thinking that, okay, something is wrong here. He wouldn't easily agree for $2 million for something, some case which has already been lost. Why is he agreeing for this $2 million, is what she's thinking. Then something strikes her that day, because he hasn't been picking calls after that 1 week also. He has calmed her down, saying that I'll pay you the money for your client, I'll give the justice what she needs. But then he has been missing for 1 week, and he has not been taking the calls also. And then she thinks, okay, what has gone wrong? And then is reminded of this limitation statute which I told you, which nobody usually cares about. So what is the limitation? It is like, if you have a claim against someone, you should institute a legal claim in a court of law within a certain period of time. For example, for civil matters it is usually 3 years, for property matters it is 12 years. So like that, there is a time limit within which the litigation can be taken. And this particular point has been beautifully used by Sidney Sheldon in Rage of Angels, that it actually brings out the importance of how one always has to be aware of the limitation period while thinking about instituting a case. Because on that particular day he has been avoiding the calls, she still doesn't know, she still thinks that he is going to give the money under the out of court settlement. So she has filed the case in the court of law. She hasn't reopened the case. She hasn't filed the papers. But it so happened that he knew about the statute of limitations was running out on that particular date, and that's why he has been avoiding talking to make an action from her end. So this brings out what specific performance actually means. These are humanized, and when emotions are brought together in this, these legal concepts become very much available and understandable for the general public. And Shakespeare also has been using a lot of legal concepts. For example, in the Merchant of Venice, Shylock, the money lender, has agreed to give a sum of money um, without interest. But if the hero of the play, he defaults in the payment of money, he would take a pound of flesh. And the person did not pay the pound of sorry, the amount of money which was owed to Shylock. And later on, he sues the lender. Shylock sues the person in the court of law, and he insists on specific performance of the contract. Specific performance means whatever you have agreed, that only I want. I don't want any money, extra money or extra compensation. I don't want. Whatever you have promised me to do, that alone you do. So you said that if there is a default, I can take a pound of flesh. So I'll take only a pound of flesh. So this is called specific performance, and Shakespeare has beautifully brought that out. And Portia, the borrower's friend's um, wife, she disguised herself as a neutral party who comes to the court, and she tries to save Antonio, who is the borrower of money. And she actually has to be a specific performance. You take the pound of flesh, but give thee here no jot of blood. The words expressly are a pound of flesh. Take then thy bond, take thou thy pound of flesh. But in the cutting it, if thou dost shed one drop of Christian blood, thy lands and goods are by the laws of Venice confiscate unto the state of Venice. So she beautifully brings out what specific performance actually means. You wanted only a pound of flesh, but in the cutting of it, you shouldn't even let a drop of blood drop. So if you can do that, go ahead and draw a drop pound of flesh from Antonio. And Shylock accepted his defeat after that. There was a long conversation after that also. So this brings out the concepts of contract and how it is considered very very sacred, because even the king couldn't undo the contract. He said specific performance has to be done, and then this visitor came, so all these things happened. So the way literature looks at law is by humanizing it, which is much needed, because in the written law that much of humanizing is not there. So giving it emotions and foreseeing what a particular piece of law could give rise to, what problems it could give rise to, what loopholes it could give rise to. And then the third leg of my presentation is regarding how the judicial system borrows from artistic literature. See, the laws could be plain, they could lack in emotions, but when a judge delivers his judgment, and when he pronounces his ratio decidendi, again a Latin term, ratio decidendi is just nothing but rationale for arriving at a decision. So when he gives his ratio decidently, he always has to evoke the human emotions, because only by making something intuitive and humane will the judgment look rational and acceptable for the society. So when that is the case, judges often quote from literature. Very often they quote from literature, especially in very very important cases. They do quote from literature. Shakespeare has often been quoted. And for example, I have given some list of things here. The Supreme Court of India described the position of the then prime minister in the 2G scam case. The Supreme Court quoted Shakespeare saying, "Uneasy lies the head that wears the crown," which means that the then prime minister must have done something about those things. While striking down section 377 on same-sex relationships, Chief Justice Deepak Mishra quoted the line from Johann Wolfgang von Goethe's "Love in all guises." Judge himself, the Chief Justice himself, felt that if a person, this is much similar to the discussion in the previous paper, which was presented by Dr. Thomas. So, if a person is denied his what he is as a person in his mind, in his body, then it is denial of his very existence. So, he did quote this particular line in and Bob Dylan's lines have also been quoted here and there, and Urdu lyrics of Mirza Ghalib have also been quoted in several judgments, especially in Aruna Schonberg case on euthanasia, whether she could be permitted to die. It's a very very poignant line. मरते हैं आरज़ू में मरने की, मौत आती है पर नहीं आती. So it's like somebody like there longing for death because she couldn't do anything else, and death is around, it is very much there. She could die at any moment, but she didn't. So she was longing for death. So this sort of evoking or depicting, demonstrating the human emotions which are there in the facts and circumstances of a particular case is very necessary when drawing the judgment. So that is what makes renders the legal system somewhat humane. And so I would conclude saying that law and literature have always been scepter that in the caduceus, and law represents the solemn will of the legislature. The solemn will of the legislature is the state, and the literature, on the other hand, is the mind of the masses. So these two have to go together and expound on law in its own way, and the law must also draw from literature to be humane and to have some life of itself. So with these thoughts, I'd like to close my paper presentation. Thank you very much for
Thank
the
you, ma'am.
opportunity. Thank you.
Now I request Manjunatheshwar Prasad, operator privileged at Eternal Infotech Private Limited, Bangalore, to present this paper.
Uh, so we can't hear you.
Okay. Sorry, I was in mute. Okay. Good evening, everyone. I'm Manjunatheshwar Prasad. I'm working as a operation analyst in Daily Hand, Aka Ita Infotech company. This company works on news app called Daily Hand. So I hope that everyone know about Daily Hand. Okay, I'm not taking much time. I'm getting onto the topic which is assigned to me. Okay, hope shall I to be
Is it audible? Is Manjunath audible?
No, he's not.
Manjunath,
okay.
please
Okay.
unmute.
Okay. Sorry. Okay. Yeah. Yeah. Okay. So I hope that my screen is available for everyone, right? Hello? Hello?
No, sir.
At the moment, I can't see your screen.
Oh, just a minute. Okay. I have some
It
technical
it
issue.
was visible a while ago.
Okay. 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 I'll show you. Show you. Right now?
Yes.
Okay. 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 I'm sorry. Really sorry.
Uh,
Uh, my topic is based on cinema literature and legal studies. This is each the three subject is interlinked with each other. So how the legal studies or how the law controls the cinema and literature, how and how it works as per the course and conducts which is formed by the law or legal studies. Okay. So the topic will be divided into three parts. One is the laws majorly focus on Article 19A is freedom of speech and expression. Under that, censorship comes under the second obscenity law, the protection of cultural heritage, copyright law, and nothing but copyright law, nothing but piracy, anti-piracy law. Okay. The second part will be based on the conspiracy theories, which made most personalities. Okay, so let's go to the first topic. Speech, as well as ideas, as well as uh, value of information. Either through it will be by writing, either through by painting, or either by vocal word, or by any visual presentation. And he can the give his thoughts and his opinions on the certain things what he thinks to be expressed to the society as okay. Under the same thing, under the same Article 19A, the government has the power to restrict the person's right to speech or freedom of speech and expression through to uh, avoid defamation, to avoid public insecurity, and to also the it also the what we call if the person is directly targeting the court or the targeting directly to the state, it can the law also comes and holds the person and asks that dude, you are looking, you are making a wrong sentence and you are making wrong pointed against the integrity of the state or integrity sovereignty of the state, or you are making a false allegations on the person who is in the who may be a common man, or who maybe is celebrity, or who may be a person who is working under the government. And it also make show it also ensures that the dialogues or the writings or anything which is expressed by the person, it should not be harm to the society. For example, if a person calls that Hinduism is a Hinduism practice bad cultures, and it doesn't have any meaning. It is no, it is full of rubbishness or foolishness. This can harm the Hindu community or other beliefs who follow the Hinduism. So the Article 19A also makes sure that person who doesn't directly target or misconduct or do any miskind of behavior against the society, which can create communal which can disturb the communal harmony or disturb the personal beliefs of the society. So the second thing comes obscenity, censorship, and defamation law. Censorship law was introduced in 1975 by Srimati Indira Gandhi. I think most of the people know about the emergency era, where the most of the citizens were kept under scanner, or even the government has the power to government has monitored the persons who were also involved in the government public works, like social integrity, conducting social integrity, social programming, or conducting any canvas against the governments, or making any social liberation programs like that. And even also it has also controlled the and other type of media, who and made sure that the media or the cinema or any kind of other things, things which should not write against the government. So the censorship law was bought, and it was executed well executed under Srimati Indira Gandhi. Second comes the Official Secrets Act of 1924. This act makes sure that the secrets of the file of the government, which should not be leaked under any circumstances, or it not be shared by the person to the other country. Other country means like our enemy or the friendly country also. So and the third one is defamation law, which was introduced by Rajiv Gandhi in 1988. But only through for but only it was withdrawn due to the opposition of political parties and nationwide strikes. Then Absolutity Act, which it was introduced under British Raj in 1860. The Act under certain various laws, indecent. One was indecent representation of women. Second was Cable Network Act in 1995. And third one is Cinematograph Act 1952. The Young Person Harmful Publication Act 1956 and Information Technology Act 2000 and on. The main obscenity means that the person or the newspaper or the cinema or the any other thing should not show the nudity of the of the person or the person if a person who writes the book or who writes the anything, we create the creativity made by this person should not be copyrighted by this person. Like example, if I write a book and that book is copied without my knowledge, and it is published in other sector, then it will be, then I can charge the copyright act against the Y person who has published my book without my permission. This act was this act was brought in Jan 21, 1958. The second act was also renewed, and the new amendment was brought on 2012 under the Copyright Amendment Act 2012. Act Normally what I said, that the law protects literary works, dramatic works, musical works, artistic works, cinematography, films, and sound recordings. All these items comes under the Copyright Act. And the last, not very, the piracy law. Piracy law was introduced under the Act of Copyright Act under Section 65, which gives technology protection of measures like a person who cannot modify or morph or copy the written things through soft copy like PDF, eDocs, or it cannot be transferred to pen drives or any storage data. And under second, the same second section also gives the information right management. Here, this amendment helps the person who has written the book. He can give the information clearly, that with clarity, that this should not be copied or executed without his knowledge. One thing. Second thing is that it also gives the right for the main author who can capitalize of the copyright of his own book, where if and he can also track the record, or whether if it is pirated or not. And the new thing is Information Technology Law 2000, which also brought under the central government. This helps that online distribution of illicit content cost penalty. If a person if you are downloading if you are downloading a movie, or if you are re-recording a movie and sharing with your friends or principals, can cost a penalty of 2 years and certain amount of penalty. So this is the second part. Here we can discuss that how the communal harmony and social cultural sensitivity gets impact on the gets impacted through literature and cinema. Like, cinema and literature is interconnected, and they are the representative of the creativity of a person who who wants to show his creativity to the entire society, or the or we call a mob or a public audience. Here he has to take care about the society in several points. One thing is, the whatever he is going to produce or whatever he is going to exhibit should not harm the social integration. Social integration means that if a person is particularly targeting a particular community, but in positive way, on either in negative way, it should not harm the community. Or why? Or else, if we damage the social integration of the society, then it will be create many causes, conflicts, and also misunderstandings. For example, if you think that if a person writes something, Ram Ram Satya Hai, Allah is no Allah is false, then this makes the thing that the person who writes this one, he thinks that Hindu Ram is true and Allah is false. Then his belief will whatever his belief will be, if he tries to narrate this one into the other community, the community will get misunderstand or miscommunicated, and some kind of thing that look, this guy has this guy is only supporting Ram and he's not supporting to Allah, so we have to boycott him or we have to take revenge against him. This can spoil the integration of the society. So the person who always who who try to write his creativity or literature or anything or cinema, either drama or any place, he must be carefully think that whatever he's writing, that he should not cause damage against the social integration and community relations. Every time the person, maybe the author, the actor, the writer, or the director, or the producer, or any XYZ, the person must be think that he's also a part of the society, and he have to give a good he have to make a good communication channel between communication community and himself. He also think that whatever he is going to execute to the community, it must reach and in a proper manner, and it should give a positive book with the targeted audience. Okay, and polarizing force. Polarizing force that is nothing but it is called as a diplomatic way. Either if a person who, for example, just take an example of Kashmiri fights or Kerala fight movie, where the thing was narrated on the damage caused on Hindu Kashmiri pandits, or maybe through through the belief of X party. Okay, I am not talking the religious name because it will make a create a bias. So, for example, this no, when the director said that no, we are not targeting any X religion or Y religion, we are just focusing that what happened in the society. So it is a open book. So please don't give and expelled comment on this one. Just think what is going on, and this should not be happening in our society. That's the way the director has communicated through his film to the audience. But in certain areas, the movie has taken took a negative impact on the other the persons, and they targeted directly. So here the director never supported the ex religion or ex party or ex community. He was very tactically polarized. He was just was diplomat. He was just targeted on the bang on his point, and he never said that I'm not making any false allegations or any things to the any society. So this is called a polarizing forces. So if you think if you are creating a element to the society, if you are writing a book or if you are creating any book, producing a movie, and this can cause a negative impact or positive impact for a certain society, that can impact on the works. So yes, that can cause impact on your work. So you have to think and you have to stay polarized, and you doesn't have to uh, what we call that, किसी को छोड़ना नहीं चाहिए मगर छोड़ना नहीं चाहिए मतलब don't give up anything, like no just if you think that, oh, I am supporting Hindu, so Hindu will help me, Muslim will not help me. If you should not think about that one. This is called a polarizing forces. And let's come to the conspiracy theories. Media is always called as a watchdog of democracy, but most of the today's medias are never thought as a watchdog of democracy. Because one thing, most of the media houses are owned by corporate world or politicians or etc. But behalf of that, some medias like cinema or folk media or other things, they are working as a delegations of the society. So they have to bring the people's public belief, and they have to execute properly, and they need to work for the people and for the society. In one way, I can say that the media is a mirror of the society, where people can express their views, their problems. They try to sort out. They try to go to media and ask their help to sort out the issues. Or media also focus on inform the society that how government moving, how the country is going, how the society is developing, how we can contribute to the society or this. But at the same time, government allegations. Media can also target the government, that if government is not working properly, that you can target the government to go. These are the problems which are government is not facing. Government is not conducting any movement or any solving any problems like this. And you can also ask that government why government is keep quiet in certain issues, or which why government is not properly peeping out their nose because in solving the issues, and why this happening. Media can ask the questions, media can point out the questions, but certain things is that when when certain media, when they raise the voice of the people or society, and protection and the government, and in case by that way the government or the so-called bureaucrats or so-called officials or so-called um, politicians, they try to keep the mouth of media. They can try to keep shut the mouth of medias by giving more monies or doing blackmails or any threats or anything. You can see many things which has been gone ups and down Corona times, and recently also. I can give you a best example that when Karnataka got arrested during the Jayalalitha's government, the Jaya TV focused only on that thing. It had a live coverage of how Karnataka was arrested, how he was treated badly, so badly, and same versa. Recently, Arnab Goswami was also arrested in Maharashtra. The Shiv Sena party showed the live how he was correct, how he was illegally treated, and how he was arrested in circumstances. So this can also shows the this also shows the allegations how government is manipulating the media to its own tune. Second is public perceptions. Look, one thing. Most of the people, I think, most of the people never follow Doordarshan because Doordarshan channel as considered as a is just a government channel because it always focuses on government programs and it only tells about government things. So this can be this kind of mentality comes under the people that people said, "What? Yeah, this channel shows only their party things, or this channel shows only negative things. This channel shows only development programs, which doesn't, which is not important for the people." This kind of public perception creates more conspiracy theories and under the ban politics. So next comes the left wing and right wing. In today's media, is divided has a right wing and left wing, and not only media, everything like literature also divided into left wing and right wing. Cinemas also divided into left wing, right wing. If for example, I can say that when Adipurush was released, it was totally told that this was a complete Hindu movie. No other community doesn't have nothing to use this. Nothing is with this thing. So called it from the left wing, and normally people that reject the movie because the movie doesn't had a good plot or good thought which we learned from what we our grandmother our grandparents and our parents thought about Ramayana. Same thing when indie part India alliance when they got gathered together and when the right wing said that look all the guys are getting together, all thieves are like getting together to demolish the BJP government. These are the ideologies where our work, our theory, our creativity, our knowledge being exploited. So, for example, like as I said, that the political landscape in India exhibits a prominent ideological divide between left wing and right wing. Both they never thought in this is the both things. They never have taken effort to appreciate their things or appreciate. They never thought to get together and to bring a good views to the country. Second is policy processes. Yeah, left policy always difference will be a difference. Will has a difference against the right policy and right wing policy has a difference against right wing policy. But the thing is that they claim that they both are different, but on the paper they come together and it is the same paper. They are just copying and they are saying that this ours, it is ours. This is the policy perspective and political movements like you can see that when Anna Hazare under when Monmouth was there was under threat against corruption, yeah, where Anna Hazare and lots of leaders together joined together and started the this mob called corruption chodo Bharat Sonia corruption chodo something where they totally fought against Sonia Gandhi government and they literally got success against the corruption. But later on, what happened? They said that we will bring back the Ramasera and everything will be done under the scanner. No corruption will be happened. But what happened? Same. The things are again getting repeated, but that in हिंदी में they will say that अगर कोई बिल्ली दूध पीता है तो समझता है कि दुनिया कोई नहीं जाता है दुनिया को कुछ भी पर नहीं पता होगा but the thing is that the cat no, but the real truth is that world knows what cat is doing and how the cat is drinking the milk. That's a that is a sarcastic point where we can see that political movements are just focused on their uh, their ideologies, not for the welfare of the society or not the welfare of the common man. Like, and this is I already said that ethical considerations. Everyone has their ethics, but never it has been satisfied to the common man or satisfied for the welfare of the community of the society. Just it is called as ethics and morality. So both cinema and literature raises ethical questions presenting audiences with more moral dilemmas. Normally, a cinema is a dream which is a dream where people fell into the imagination world. They think that this hero is good, the villain is a bad, and the hero is working for a good for welfare of the society, and he's fighting against the bad odds like this way even the some kind of cinemas give the clarity of that how the society is being framed under the under the circumstances where good and evil is joined together and showing their face to the society. So influencing of social discourse, like if you social discourse is nothing like social evil practice where certain practices are done, which has been eradicated. Like you can see that Padman movie which brought a knowledge how the this one how the women are being falling in the stigma or taboo in the rural areas where people where lots of women think that using sanitary napkins as a ill or sin. So these kind of social stigmas are being removed and they have the movies have given good knowledge about how to make clear or how to be the society how the culture community and the society can be kept clean as good as our health. So the cinema literary works makes sure that the audience, targeted audience engagement should not be fallen back. It makes always try to make to create a good impact on the audience, and they try to communicate with their narrative strength. So normally, in India, cinema and literature has legal challenges like censorship and controversy. Government has some kind of censorship. They restrict cinema and literature, and make sure that they should not cross their beyond limits like obscenity or targeting a particular audience with negative form of negative things, misconducting, misbehavior, miscommunications, with false narrations, or giving a bad impact on society like this. It also impact on creative expressions. If, for example, if I think, for example, in my society, I think that certain people are facing some problems which is no unknown for the other society, and I will try to make a creative work like either maybe it be writing or a documentary or anything, and I'll try to show to the other audience and make them to understand that look, yeah, we people are facing some issues. You have to come and see, and you must know the idea like what in Kashmiri Files, what the director tried to narrate the problems of the Kashmiri Pandits. This kind of creative expressions can bring an impact to the other audience. Unless Kashmiri Files, no one had known the idea how the Kashmiri Pandits had faced the problems. These are legal precedents and policies There are some policies and some legal precedents where these kind of works can be made under the scanner, and they can be rewritten or re-edited or rethought and rephrase it and brought to the mainstream. So let's see the influence of legal concepts in literature and cinema. The impact of storytelling, which includes the inclusion of legal elements, enriches narratives, adding complexity and depth to the plot lines. The representation of legal themes, both cinema literature and cinema often incorporate legal concepts and themes reflecting society's views on justice, morality, and ethics. Cultural reflections. Legal elements in literature and cinema can mirror societal norms, values, and concerns, providing insights into the cultural context. So here, version. The impact on audience can be seen that the transition from a page to screen can significantly influence how audience perceive and engage with the stories represented. For example, if you read a book and if you go through the imaginary, cinema is you can imagine how that book is the author story is going on. But in cinema, the word by word and are being made crisped and edited, and they try to show in the visionary way, visual way. So, a hundred pages of book can be made in 10 minutes of video. That can be made in 10 minutes of video. So if a person takes 100 pages of book to takes almost 10 to 20 minutes to read, a cinema gives 5 minutes of visualization. That's what cinematic adaptation can be seen under literary works. Literary as source material. Most of the time, you can see that this movie has been taken from true stories or taken from the courtesy from this and this by X book or by others creativity and visual interpretations. Visual interpretations always goes with the knowledge of the director and the author who tries to elaborate the story and who try to communicate his words, and who the director who involves in that, and he creates the image visualization according to his imaginary. So visual interpretations comes between the concept of the author and the imaginary of the director. So critics and controversies under the how the movies are faced. Some cinematic argue just two examples of movies name. Like good movies have always had an impact on both critics and audience. Movies like Tare Zameen Par and Super 30 have played a significant role in shaping public opinion and in providing a critical analysis of movie content. Tare Zameen Par was made for the special children, where who were who were really fighting hard in their physical and mental development. So at the same time, so Super 30 was a movie which was focused on the rural students who wanted to get passed in IIT exams. So these two movies made social impact on the society and got a good critics about their views from the public opinion. So the second point goes to controversial films. The it has been mild controversies surrounding censorship and artistic expressions. Special examples of such controversies were Kashmiri Files and Kerala Files and PK. These three movies were faced boycotts also, and most of the states tried to ban these movies because they thought that this movie may create conspiracy or may disturb the society. And the social impact, third point is social impact. Movies like Bombay and Uttar Punjab face controversies and critics that often stay in the entire film industry because Bombay, the movie Bombay was so based on the communal roles in the country where the in that movie where a Brahmin boy marries a Muslim girl and the circumstances and how they face their life in threat while committing violence and how they survive. The other movie and Uttar Punjab was a completely youth-oriented movie where protagonists used to commit crimes by using drugs, alcohol, addicts. These two movies had their own version of impact on the society, and they created lots of controversies among the communities and the public audience. So this is the third and last part where I take three personalities and their era. Okay, I will just read out the points and wind up it. Okay, under the Nehru's point, we know that Nehru was a good politician and a good, well-known Prime Minister of India. But there are some dark shades of Nehru's also. So this slide focus on that one. Under the Jawaharlal Nehru's tenure, various literary works, musicians, and movies were banned or censored due to political, religious, or social concerns. Some of them are 9 Hours to Rama. This book was based on how Nathuram Godse killed Gandhiji. So it was written by Stanley Walpott. Lady Chatterley's Lover, B.H. Lawrence, A Suitable Boy by Vikram Seth, Satanic Verses by Salman Rushdie. The musicians like Elvis Presley, the Beatles is a music band. Majru Sultanpuri, a well-known Bollywood lyricist and a big Hindi poet, was also put into the bar. Especially, I say Majru Sultanpuri because one of his poem he said that Nehru was a Hitler's ka chela. So that's why most of his poem, his songs were banned, and this person was put in the jail. So the movies where the banned was Ganga Jamuna, Parashakti, Neel Akshar, Niche. All three movies were focused on the Indian society and how Indian society is facing the issues on that time. So this was a big thing that harmonium was banned and all India radio. Most of the people I know hope that they have listened that the harmonium museum, the music which we tune all India radio stations. It was literally was completely banned on during the Nehru's era and then re-established again Indira Gandhi's era. So next, the personality comes in India's emergency. Emergency, a lot of things will happen. I just focus on some things which were really caused the damage on literary works and cinema. Okay. One thing is media censorship. During this area, the Indira government imposes strict censorship on the media, limiting the freedom of expression. Freedom of expression was completely boycotted, and whenever the person who talks against the government was being jailed. So no group of people gathering on the in public area were be banned, prohibited. So many movies were banned. Newspapers, literary works were bought under scanner. Even you can see that Times of the Hindu, the Statesman were gone, not publishing any single article, and they just went through white papers, only white papers, without publishing any articles, and they protested against the government that this was truly exaggerating or violating the article of 19A. So musical programs are literally boycotted in air, special Central Board of Film Corporation where became government's puppet toy, and many movies were asked to re-edit wherever the dialogues are sayings which portrays the government's action or anything or any word comes against Indira Gandhi or anything which also made asked to cut and re-edit, and then they come under the scanner, and then if the movie is okay, if the the song is okay, then they use it to exhibit the movie. Okay, R and raw research and analysis wing was used as a spy on actors, artists, and writers, and also politicians also. Okay, and awards, and during that time, many writers, many well-known writers, many artisans, many literary works were prohibited the government facilitation, and they tried to return back the awards the government policy. Now, movies like Andi, Garam Hawa, Kissa Kursi Ki, Nasbandi, Hirakal Raja Deshe was banned because portraying the dictatorship of Indira Gandhi. Then comes our well-known famous person, Narendra Modi. Under his regime also, there are some kind of things which has been banned in the name of saffronification. Some of books are thus Sunrise over Ayodhya, Nationalhood in our times by Salman Rushdie, which was really banned because that book was really protected against the black things, black stories, untold stories about how Ayodhya was there formed and the involvement of Babri Masjid, government, Supreme Court law case. They are all things were mentioned in the book. It was really banned by the so-called BJP government. Jinnah, India Partition Independence, which was written by a BJP person, ex external affairs minister, Jaswant Singh. It was also banned. It was banned because the book was mentioned in that mentioned about Jinnah how he fight for the Pakistan independence, and he what is his role of role of uh, what is his role in the independence and partition. So this book was also banned. The Adivasi will not dance by Hansida Somvendra Shekhar. This was also banned because this book was focused on the tribal community. And last but the least, the India, the Modi question. I know that most of the people know this documentary name, which was published by this documentary was published by BBC. They tried to publish, they tried to put on YouTube and exhibit on in India, but later on that BJP government has put the ban on this one, and with help of Supreme Court also. So you can't see this document, which is this document is based on the Godra Hatyakand in the and the role of Narendra Modi. So these were the things which was banned under Narendra Modi's government. Apart from that, I will read out some things where some famous books and movies which were banned in India. One Lajja by Taslima Nasrin. It was based on Muslim women, how they face their social stigma and taboo. Second, Rangila Rausal by Pandit M.H. Amupati or Krishna Prasad, 1927. Who Killed Gandhi by Lorenco D. Salvador. Polisher Prince, The Rise of Dhirubhai Ambani by Hamish MacDonald. The Epic of Shivaji, The Translation and Study of Kavindra Premananda. Shiva Bharata by James Land. The movies were Vishwarupam, Tamil movie, Bandit Queen, 1994. Fire movie was based on homosexual, and Action was based on reservation. Pidavum Putranum in Malayalam, and Chayam Pushevidu. I think it comes to incest relationship between father and the daughter. Second, third one, the Oreoru Gamathil is 90, from 1997 in Tamil. Next comes India's Daughter, which is focus on Nirbhaya rape case. The problems of Kashmiri Pandits, 50 Shades of Grey, erotism, Water. Water is a movie which was made on the widow remarriage, which was completely boycotted in some area of highly cultured India, highly cultured state. And Black Friday, based on the Bombay Blast, Kama Sutra, A Tale of Love, Indiana Jones, and Temple of Doom, which was focused. This movie was on the Monkey Temple and the excavation done by Indiana Jones. Okay, that's all. Hello. So
Thank you, sir. I deem it an honor to introduce our keynote speaker, Dr. E. Ajitha, works as an associate professor at School of Law, Weltec University. Madam has around 25 years of diverse experience in law. Her professional career includes private practice as an advocate, law officer in commercial bank, and nearly 20 years of teaching law. Madam holds master degree in English literature and PhD in law. She has also published articles in peer-reviewed journals and books. We are greatly blessed to have your amidst, ma'am.
Thank you for your very kind introduction. We are at the end of a very long session. I'm sorry, the person who speaks last. I think I have to go through that also. But keeping to brevity being the soul of wit, I will try to keep my speech as brief as possible. But before I go on to the keynote address, am I required to make a comment on all the three
Yes, ma'am.
presentations?
Just a
Yeah.
few remarks.
Yeah.
Just
I will keep even my comments very brief. The first one was an absolutely good presentation. If I can say it in one word, it speaks of suffocation. The reflection of society stifling the queer community, and it has been brought out beautifully by the presentation, both in the poem and in the presenter. A very good presentation, ma'am. And coming over to the second presentation by Usha Ganapathy ma'am, it is on law and literature. She concentrated more on the written law. We have a whole subject of interpretation of statutes because it is very difficult to interpret law, and I totally agree with her. And ma'am, if I can make one correction, limitation act is 1963 and not 73 like you said. I'm sorry, but the teacher in me cannot stop myself from correcting you. Yeah. Okay, moving over to the last presentation about cinema literature and legal studies. This was um, um, a very comprehensive presentation, starting from the laws, how laws restrict, and then talking about cinema, about media, about social media, about what are their responsibilities. Um, and if I can say it absolutely briefly, media is an art form, and it reflects society, and it also has freedom. As much as freedom is accorded to it under the constitution, freedom also has boundaries, so it also has restrictions. There are also responsibilities that any media person uh, has to actually fulfill, and to make it a more a viable medium, more with responsibility. He spoke of censorship and more of politics. I think I wouldn't touch upon that. I think all the three were good. I would have appreciated if they would have kept to their timing. It would have been more enjoyable. Sorry, that is just a comment. Um, Moving over to my topic, the synergy between law and literature. Law has always been um, a subject of utmost interest to a layperson, be it a crime, be it punishment, be it advocates' way of conducting a case in a courtroom, or the judgments. They have all occupied the imagination of people for a long time. So it is no surprise that law finds a place in many of the literary works from time immemorial. After all, what is literature? Literature is a reflection of life. It's a reflection of the times in which that literary work was created. It gives us an insight into the cultural, the social, the political values of the society. And we had a description of what Merchant of Venice is. I would just add to Usha ma'am's point that in Merchant of Venice, um, Shakespeare's work reflects the legal system of Elizabethan England. If I can add one more point, then sorry, okay. Um, It is also a commentary on the legal and social status of Jews in England. And then Shylock's character serves as a representation of the Jewish stereotype in those times. Um, if I would like to cite more from Tamil literature, uh, where literature showcases the times. We have a very popular story of Manunidi Chodan. It's a story of how a king executes his own son because he accidentally caused the death of a calf. So this story showcases how uh, this sense of fairness and justice uh, was a whole how it was in the ancient tradition of Tamil kings. So, literature is not only a reflection of what a layman expects of law, it is also a critique of the laws. It is also a critique of how the justice system exists, and what are the injustices that have happened in the courts. For that, I would give you an example of Silapadikaram. Silapadikaram is a story of how a king wrongfully executes an innocent person, and it is up to his wife Kannagi to prove the king wrong and to prove the innocence of her husband. We find that literature, law in literature, has been researched upon right from James White Boyd's the legal imagination, when it was published in 1973. Right from that time, this movement of law and literature has produced wonderful articles that have been it is a movement where there have been articles on how law has been a source of inspiration for many literary works, and how literature has been in law, some of which has been showcased by Usha Ganapathy ma'am. I would like to talk on how law is literature. What do I consider law as literature? For me, a judicial opinion is also nothing but storytelling. It is about the storytelling about a matter at hand, the cast, the motives, the moral of the story. It's all discernible from the kind of facts that are presented in the beginning of the judgment, and then the framing of the legal issues. And then finally, when the ruling determines who would pay for the violation of the established rules of societal conduct. To quote Justice Sikri, judicial discourse encompasses emotion in its endeavor to establish the rights and duties of the parties. So, close reading of judicial observation, it provides us with an opportunity to go beyond the text, to reimagining a socially relevant judicial process, the one that transcends the courtroom. Uh, if I can just give you very briefly, because I am very taken up by this environmental law case way back in 1997, because it's a very historic judgment, because that is when the Supreme Court has allowed the application of the doctrine of public trust for all environment. So it is like a precursor to our NGT, National Green Tribunal's judgments that are based on polluter pay principle. When you pollute the atmosphere, the environment around you, you are responsible to make sure that you restore it back. So, polluter pay principle and the public trust doctrine. What does public trust doctrine talk of? This talks of the government being an authority of it, an authority, a trustee of the natural resources that are available. And as a trustee, you cannot fritter it away. You have to preserve the natural resources for the future generations to come. So you cannot give it to private companies, any natural resource, be it water, air, land, whatever. None of the natural resources can be given to private companies for commercial use. That is what this case, MC Mehta versus Kamalnath, politician Kamalnath, talks about. It talks about how a private company wanted to build a resort on the banks of Bias, and they use their influence and get around 17 acres, 27 bigas of land, of forest land. And because of the construction, it leads to the course of the river Bias itself being changed, leads to overswelling of the river, and when there are floods, this causes floods in the river, and it causes a loss of around 105 crores worth of property. And therefore this case is very important because it's a historic judgment that has paved the way for many such very interesting and judgments that serve the cause of environment and talk of sustainable development that is so much in vogue now. We need to preserve our environment for future generations. It talks of it's not all your environment legislation have a connection with humanity, with environment. That is what literature is also about. You connect yourself to what's happening around you. So there is a relationship between law and literature. It is evident in the interpretation, in the reading, and expression methods. The relationship is most visible because both of them use vocabulary and rhetoric. Both of these genres use human experience, and they represent the reality of the human world underneath the vocabulary. And law and literature, I feel, have the same purpose as they are both concerned with the interaction between society and culture. We as lawyers learn from literature's empathy and sympathy. Literature makes us more conscious of the real world around us, what the society needs, what law, because law is dynamic. It keeps changing. It keeps changing according to society's needs, and for that, literature is a source. The literary bent helps advocates in their arguments, definitely yes, and judges in their pronouncement. We saw Aruna Schonberg's case, and literature is used to excavate legal intricacies, like in Shreya Singhal versus Union of India. Shakespeare is invoked to study the difference between advocacy and incitement. This famous speech by Mark Antony from Julius Caesar is quoted. At the outset, the speech is simple advocacy, but a deeper reading is, excavates its true character. Just one more example about how literature is used as a tool. We have our famous Justice Krishna Iyer. He had an exemplary flair, literary flair, and when he talks, when he gives his judgment in Maruram versus Union of India, this is about remission of life convicts. He's talking about the despair that these convicts face. So he quotes Oscar Wilde. He says, I know not whether laws be right or whether laws be wrong. All that we know who lie in goal is that the wall is strong and that each day is like a year whose days are long. It sort of sums up their lives behind the bars. So, one more thing I would add is critical theory is important both for literature and for law. And because both students of law and students of literature need a sharp eye for detail. And law governs an essential component of literature, such as copyright law. So let me end with saying that law inspires literature and literature communicates the law. Thank you. Ma'am, I'm done.
Yes, thank you, Dr. Ajitha, having accepted the invitation to come on, and we are it's a person
It was my
you know
pleasure.
exactly where to, and you also kept to the time. So that way, and so I mean, only for I mean, you were from the time from the days of yore when we started reading Perry Mason and listening to the all of us as ordinary readers, we are all I mean, those of us who are really interested, we just listen to the exchanges between the lawyers, and then that's why we all loved Shakespeare's Merchant of Venice. And so, and of course, as we proceed, we learn that we wait for justice. So all these things you highlighted and told us, from the not so classical works to the very classical works, very good judges have always used literature to highlight things, and I hope there are more such people to make things easier for us, life easier for us, for those who are affected. Thank you once again for having accepted. I mean, one Dr. Nirmala called you, I think, and yes,
Yes,
Nirmala is a good friend. I don't know whether you've seen me on campus long ago, but I don't know. Okay, I was also a student there, Dr. Nirmala's student. So happy to have seen you, heard you. Yes, thank
Thank you, Srilata. And thank you, Srilata, for helping me to get Dr. Ajitha. Thank you, Vinita, for arranging Dr. Usha. And of course, our good friend Shreya for bringing Lisa on board. So thank you all very much for contributing to In Tandem today. Can we just move over to the vote of thanks because we've had a very long thing. And sorry, Dr. Ajitha, I probably should have tweaked it a bit.
No, it's okay. It happens.
Yes.
We have come to the end of the session. I feel it's an honor to propose a vote of thanks. I thank our keynote speaker, Dr. E. Ajitha, for sharing her valuable insight. I also thank our paper presenters of today's session. I thank our college principal for her constant support. Our all time thanks to Dr. Maria Preeti Srinivasas, Associate Professor under Department of English for providing various research opportunities to the research scholars. I also thank all the staff members and research scholars who were presented at this forum. Thank you all, and we will meet again after Foresight on 1st March 2024 with the topic Interdisciplinary Studies, Literature and Cognitive Studies. Thank you.
Uh, yes. May I request all those who present today to feel free to submit a paper for publication. You